All right. So today I'm going to tell you all about how to get personal information. All right, today we're going to talk about how to get personal information from the new privacy laws. Exciting topic. I'm Amber Welch. I evaluate corporate privacy programs for a living. So I hope you like XKCD, even if you don't like privacy laws, so there will be something for everyone. I also like Oxford commas in reading the privacy laws so that you don't have to. I'm a privacy technical lead at an audit firm, so I go into corporations and tell them basically what they're doing wrong, and I see a lot of terrifying things. Before that, I managed a security and privacy program for a suite of hospitality SaaS apps. So I've been on both sides of this, I evaluate them, and I've done it myself. So for the next 20 minutes, I'm going to tell you about what the data subject rights are, DSRs, data subject requests, that's what they're often called, the exploits that you can do with them, and some defense strategies if you happen to work for an organization that might be subject to these. So the data subject requests, aka DSARs, DSRs, SARs, consumer, yeah, it should be. This is what happens when you use Google Slides. Okay, here we go. See my lovely cat? That's not mine. So, there, XKCD, that's what I was talking about. And you're going to have to look at these slides online so that you can actually laugh about that very hilarious comic about privacy. Okay, so we're in a global data privacy era. There are new privacy laws popping up every day, federal laws, state laws, international laws. It's something that has become a big part of the internet right now. Anybody who has stuff online has their information being accessed everywhere. It's available everywhere, transferred. You outsource everything to India. So there's a lot of information that is subject to rights of governments that you might not even really know about. So there's 4 key rights to exploit. I'm going to focus on GDPR since that's the one that's active right now. CCPA is a big one, so I do have information about that online for this cheat sheet that I'm going to give you. But since there's still amendments for it and they're not quite finished, it's also not in place, I'm not going to get too far in the weeds on that just in case it changes. So the key rights to exploit are access, which is the ability to request access to all of the information a company has on you, even stuff you can't really see through your account. Rectification or modification, which is the ability to update incorrect information about yourself. The right to erasure, or the right to deletion, the right to be forgotten, you might know about those, and portability. So most companies are subject to at least one government's laws that have access rights, because these are very common across all privacy laws. Now, GDPR did something interesting. These access rights have been in place for almost 40 years now. But GDPR added indirect identifiers to the definition of personal information, which potentially makes all information PII, because they also included the idea of, with California, household and device information, and they both decided that, yeah. Sure. Let's see if I can get this closer. Both California and GDPR identify any information that could potentially be linked to a person, even in the future, as PII. So you have a lot of data right now that you might consider anonymous, but if it could be combined with something else in a new data set, it becomes PII. So it really changes how you have to think about protection and the potential for access exploits. The Google Spain lawsuit is a really interesting idea because someone sued Google, the Spanish guy, because he wanted some information taken off of Google. And Google said, not our problem, we don't have any control over this. The EU decided it is your problem, even if you don't have control, you're still legally the controller of the data. So I asked Jason Scott what he thought about that, and he basically said, let's see what happens. I hope they don't get him on their radar. So in the US, companies are mostly unprepared for this because they haven't had these types of rights before. There's been a lot of panic. You've heard about the 4% global annual revenue fine. So when companies think about comparing giving access to an individual who asks for it versus 4% fine, they say, here you go. So their response has mostly just been provide all of the data. They see this as a legal issue. They don't see it as a security topic. Usually it's just sorted out by lawyers. They consider non-compliance a greater risk than the breach of one individual's data. So now we're going to talk about the fun stuff, what you can do with this. So bad actors, this is one of my favorite ones, the legal DDoS. Bad actors can jump in along with legitimate grassroots protest or educational campaigns. You see these show up every once in a while when some enterprising person says, this company is bad and does bad things with your data, so take your rights back. Here's a bunch of boilerplate text and the form. And maybe thousands of people submit these requests at the same time. So anybody that's a little bit also enterprising on the other side can say, perfect, I can flood you with requests with boilerplate language, which you normally wouldn't be able to get away with. It would be noticed if you were submitting lots of requests with the same text. So that's an area where there's a lot of difficulty because security and legal teams are really distracted. They have a hard time fulfilling all of those requests, and it's quite challenging. It can be very expensive. So the average manually processed data subject request costs, the only country that tracks this is the UK, and they say it's 145 pounds. So this guy asked for his information from a midwifery clinic, and it cost them 240,000 pounds to sufficiently redact the information. So other bad actors, I don't have time to go into this today, but there's lots of fun stuff that you can do with this if you have a creative bent. Phishing. Everybody wants to do phishing, right? So the new ability to request indirect identifying data is even further complicated by California's requirement that you can't make somebody have an account with you to fulfill that request. So when you think about IP address as an indirect identifier or publicly scraped biometric information, how do you tell a person no? If they have that information and you can't really associate them with that data, they never gave it to you, but you still have it, that leaves you in a really challenging situation. So another thing that phishers can do is request data for other people with their own name. So I have a very common name. This terrifies me. I could ask for all of the information from the other Amber Welch, the more successful one with a PhD who lives in London. I know this because I get her tube updates. So what Google used to do is ask for passport information. But you never made an account with Google with your passport, right? So if you send them your passport ID, which Amber Welch? One of them. I'm just one in a number of them, and I'm sure many of you are that way as well. Another tactic is escalating from low sensitivity requests to confidential information, getting that foot in the door by saying, oh, I just want to update my address and verifying information, and then saying, by the way, can I also get a copy of all of my data? You're already through that validation, so if they don't have good controls around verification, this is a good way to get in. California adding household or child data is another good potential tactic here because they haven't really identified what they mean by household data. I think IoT is going to be an area where this will be potentially very scary. So social engineering is interesting with this because you are not allowed to reject a verbal request. So if you call up a company and you say, oh, computers are hard, can you help me by phone? Then a really good social engineer has a lot of freedom to move around within that company's data. You can use that to confirm profile data that you suspect if you're trying to merge profiles from different data sets that you've gathered. You can learn new data, or it's a potential good use for freshly breached data that hasn't yet been disclosed. And when you're evaluating a target, stay away from the privacy officer. The privacy officer does nothing but think about these problems. So they're a lot more likely to pick up on this stuff. A good way to evaluate whether a company is a target for this is to look at two things: their executive page and their privacy policy page. So the privacy policy will tell you if they have really vague or maybe old information on there, no named privacy officer. If there's no executive with any privacy or security responsibility, they probably have quite weak controls for this. Also, some companies are doing DPO for hire, which is just a service where you can have someone act as your DPO. You don't get a lot of attention, and they don't know anything about the business. This is a tool called Pribot.org. It turns any privacy policy into this nice little alluvial diagram. So you can see this one at the top that's weak. It just kind of narrows down into what they call unspecified choice, which means there's really no information in there at all. So if you see a good, strong policy like that, it has a lot of information and it gives you a lot of detail about what you can do with the privacy. So weak targets, there are a few profiles that I see as common problems. Companies that have a high volume of indirect identifiers that don't necessarily require an account, especially one with a name. So places where you might not have an email address associated with an account. You can make an account without really doing anything else. Or places where you might have an account that's entirely offline, where you haven't really made any kind of login information. It's very difficult to authenticate that person. International charities are subject to a lot of privacy laws. They really want to be helpful, but they don't have a lot of money, so unfortunately, usually a good target. Social media startups tend to not care a lot about privacy because it's boring compliance stuff, but they get an awful lot of data, and they are data controllers. They're B2C, so targets that probably have a lot of leakage. And then the small and medium businesses in minimally regulated industries like hospitality, entertainment, they kind of know that they have to follow this stuff, but it's not like they're HIPAA or anything. They don't have any important data, right? So they don't tend to pay too much attention to it. And also, apps without 2FA. This is what happens if you don't have 2FA. If you have a policy where somebody can get all of their information through just authenticating, then, you know, easy. All you have to do is hack in. So the thing that scares me about this is that regulators have known this is a problem for over 40 years. And yet security teams really don't tend to get involved because they don't want to. People don't like to talk to lawyers, and if they don't have to, they won't. So what can we do for defense strategies? Now that I have told you all of the terrifying things, you feel a moral obligation to do something about it, right? As the person with common name, please. So this is how DSRs are usually processed. Request comes into a generic inbox, either support or maybe a legal team. The intake team decides valid, invalid. Low risk, valid requests go to the support team, maybe a password reset even. Valid requests that are high risk or manual processing usually go to a legal or privacy team, and then they tell IT or a DBA, okay, delete this person, let us know when it's done. So the challenges with this, we know that identification is really difficult, and in this context, even more difficult. There's insufficient data often to link a person. You might identify a human being but not know what record goes with them. You can't require California customers to make an account. You can't collect even more excessive information for the purpose of verifying ID. So you have to work with what you have, and you can't make the process burdensome. Also, if you do need copies of identification documents, you're just adding more sensitive information that you've collected. And then even services like gov.uk's Verify service is only 51% successful, and that's their statistic. So what do you do? What's safe? There's really only two good methods. Confirmation from the user themselves with 2 or more transactions, some kind of account history. The reason you want 2 or more is because if I go to the hotel bar after this and I pick up somebody's receipt, I have their information, their date of the last stay, and maybe a transaction on the account. So for an organization that is only validating with 1 piece of transactional history, then almost anything you do in your daily life could potentially become identifying information for a DSR. So this would be an example. When did you last stay at our hotel plus the last 4 digits of the card on file? The other thing that you can do is confirm identity as already known by the organization. So you can use things like driver's license or passport, but only if you already have that information on file that was already associated with that person. Don't just give, John Smith's information out to every other John Smith. And you have to kind of assume that those IDs are probably compromised, so you would be looking to potentially get scans of this to actually see that they have possession of the document. So the key thing to remember here is that you don't need to know the person. You need to know that the person making the request is the same person associated with the data. If you never actually find out who that real human being is, that's not actually that important. You just need to make sure that that person is requesting the same information associated with their own history. So here's my cat, because I know this is long. So take a risk-based ID process. Graduated ID levels for low to high risk data. Don't let somebody escalate to a higher level of information based only on the fact that you talk to them on the support phone. Assume that all IDs are compromised. The NIST digital identity guidelines are pretty good, a safe bet, and can also give you a lot of compliance kudos with regulators if you ever did have any problems. And deny any high risk, low confidence request. If you're just not sure, say no, document why. You're not going to get in trouble with regulators if you have a good reason for denying that request. You just have to say why, and you have to explain it to the person who's making the request. When you do a denial, you can give the person the information for the regulator that they can complain to if they want to escalate it. So legitimate requests have a way to escalate, and then scammers are not likely to do that, obviously. So some ways to minimize risk: use automated self-service when possible. Please only do this if you have good 2FA. If you have a manual DSR process, consider adding a notice banner to the UI, so if somebody has maliciously created that request, then the real user will see it when they log in. Don't export any data that the user can already access. You're not required to do that. So if it's available to them in the app, just tell them where to find it. Don't send it over an insecure method. And then use secure communications for any ID verification. Please do not make people email passports. All right, remember that you're trying to meet the true need. The heart of privacy laws is to honor what people actually want. They want control over their data. They want to have a little bit more insight into what you're doing with their information. So sometimes they need a password reset. Sometimes they just need help navigating the application, or they might only want a certain piece of information. No reason to export their entire file if they just want to know one specific thing. And these are some red flags that you can look for. Keep a few metrics on your system to make sure that you're identifying when you have a high volume of requests, a lot of strange requests, text that looks the same. Kind of pay attention to what's happening across multiple requests if somebody's trying to figure out your process by submitting 3 different types of requests and seeing what you do with them. And default to denying all requests. Make them show you why it's a valid request. Don't just give them the information. Like I said, it's not a problem if you deny them. You just have to explain why and give them, don't make it impossible. Let them actually get access, but only if it's truly valid. So these are all reasons, according to the GDPR, that you are allowed to reject requests. So this is all on the cheat sheet. I give the legal text as well, so you can find that on this GitHub. I haven't actually added the part for the exploits under the GDPR yet. I will be doing that on Sunday, but that includes all of the legal relevant sections for both the CCPA and the GDPR, both for the exploit side if you want to try to do some red teaming or pen testing with it, and for the defense side if you'd like to brush up on your security. All right, I'm out of time, but if you have questions, please find me afterwards. I love talking about this. Find me on Twitter. I'm happy to hear about your stories or tell you where I found my great cat.